this next panel on electronic discovery and the evolution of Rule 16 in the digital era. I'm now going to introduce our moderator, Rob Cary. Rob has become a good friend. I really admire his accomplishments. Rob is a member of the American College of Trial Lawyers and co-chair of the firm's liability practice at Williams & Connolly in Washington, D.C. He's well known for many litigation triumphs, but one of the most prominent is his representation of the late Senator Ted Stevens, who was indicted on ethics charges less than 100 days before he was to stand for re-election, and he was acquitted in this trial. He was described by the American lawyer as one of the best criminal defense performances in memory in that case, resulting in a heightened scrutiny of prosecutors that will affect the Justice Department for years to come. Importantly, he is a graduate of the University of Virginia School of Law, and before that, he had a storied career as a football player and an academic at Dartmouth College. So without further ado, let me introduce you, Rob. Thank you.
Thanks, Joe. Our first panel this morning is on electronic evidence, and I'm joined by three great panelists. Meredith Kingsley is a partner at Alston and Bird, where she engages in a civil and criminal practice. In addition to doing investigations, she also does commercial cases. Those of you who were here 2 years ago remember at the dinner how she dazzled us with stories about her federal murder trial that she tried in Georgia the preceding year. Next to Meredith is Simon Latcovich, my partner at Williams & Connolly. He also just finished a federal murder trial last year, a different one. Actually, he's one more down. He is also has a civil and criminal practice and is working on a chapter for our book on federal criminal discovery, on electronic discovery, so he's up to speed on the latest. And then in the middle is Ann Tompkins, who was the U.S. Attorney for the Western District of North Carolina. She served on Attorney General Holder's advisory committee, where she served on the White Collar Crime Committee, a leader at the Department of Justice, and a prominent prosecutor, including the case of General Petraeus, where she and Simon are on opposite sides. And I think this is emblematic of the type of conference this is, where people on both sides of cases can get together and discuss the issues. Before being at DOJ, she's at Cadwalader now, but before being at DOJ, she was a defense lawyer for a number of years, was an AUSA, and then is a defense lawyer once again. She, in addition to having lots of recent experience with e-discovery, she also remembers the day that many of us remember, who are young baby boomers like Joe, when you could go to court with a red weld full of documents and try your case. So she'll give us a wide range of experience. So this is called the evolution of Rule 16, and so I wanted to start off by talking about Rule 16 just a little bit. And we've got a slide up there, which is an article from the New York Law Journal in 2017, in which the authors, who were with the Morvilla firm in New York, wrote, quote, "Buoyed by a recognition among the judiciary that current practices must come to terms with the proliferation of electronically stored information, and by the Department of Justice's acceptance of the principle that amending the rule would be useful, it now appears likely that an amendment will result." So my first question for you, Meredith, is, was there a meaningful amendment to Rule 16 as was anticipated in 2017?
I think we all know the answer is no. As of December 1st, there will be a rule coming into effect that requires a discovery conference, but it is a light touch at best, even with respect to details of that conference. There's no requirements, there's no timelines, there's no requirement of blessing by the court. It's merely a suggestion or a requirement now that both sides meet and confer and try to come up with a plan. And we'll talk today, Rob, about all the challenges with coming up with that plan and the lack of guidance that the federal judiciary has in setting the parties up for success in the discovery space once an indictment is issued.
So I've just put the rule up, and I know you guys have a hard time seeing it there, but I've also got the committee note for Rule 16.1, which reads, because technology changes rapidly, the rule does not attempt to state specific requirements for the manner or timing of disclosure in cases involving ESI. However, counsel should be familiar with best practices. For example, the Department of Justice, the Administrative Office, the U.S. Courts, and the Joint Working Group on Electronic Technology in the Criminal Justice System, JETWIG, have published recommendations for electronically stored information, discovery, production, and federal criminal cases. That came out in 2012. I think, Ann, you were a U.S. attorney at the time. What was that? What is that document, and what use does that have to us practitioners?
So when I came in 2010 as U.S. attorney, and that was right on the heels of the Stevens case, and the department at that time, for most of y'all were practicing then, took it very seriously, the failure of the department in the Stevens case. The way that the Department of Justice likes to deal with this stuff is not to codify their requirements. Rather, as you all know, they like to use the U.S. Attorney's Manual for guidance. And that's what the department did at that time, starting in 2010 and then in 2012, to put out sort of best practices guidance. And that really has remained, from regardless of what the administration is, the preferred tactic of the Department of Justice is to put out best practice guidance, do training, hope for the best.
So Simon, Ann made reference to the Stevens case, and have there been other attempts or efforts to amend Rule 16 over, say, the last 15 years or so?
There have. And most of what we're going to talk about is not related to those amendments today, although as you'll see, the issues are intertwined. There have been efforts to modify Rule 16 to enlarge the Brady obligations of the government, require the government to produce all exculpatory evidence as opposed to just material exculpatory evidence. The American College of Trial Lawyers put forth a proposal in 2003. The advisory committee actually recommended adoption despite some pretty ardent DOJ opposition. It failed ultimately at the standing committee. It was raised again by Judge Sullivan of the Ted Stevens case again after 2009 and defeated again. And so at this point, there are no pending amendments to Rule 16 to address the Brady issue. That's not the same as the electronic discovery requirements that Ann was just talking about. But as you'll see, when the rubber meets the road, these issues have a way of coming back together and influencing how the parties act.
Yeah, so I have a theory that the great issue for most of the time any of us have been practicing law, at least on the defense side, is Brady reform, Brady reform, Brady reform. Can't we get a better Brady rule? Can't we get one that isn't limited to simply that's material and that where we can get everything that's favorable? I actually now think that in today's world, the post-Stevens world, and with all the electronic evidence that there is, that we have a new problem, and that's too much information, and that's one of the things we're going to talk about today. And there may still be witness statements and specific Brady issues that arise, but I think the bigger crisis for our criminal justice system is how to deal with too much information. And I have some slides that show some of the sources of information that I think affects not just white-collar cases, but blue-collar cases as well. Those of us who live in the District of Columbia, Shana Fulton's out here. She used to be an AUSA in DC. Officers wear body cameras in DC now, and there are a lot of officers, and that creates a lot of discovery. There are poll cameras and surveillance cameras all over Washington, DC, and many other major metropolitan areas. Those of you who travel to the UK a lot know that in London, it seems like there are cameras everywhere, and you can see them everywhere. Home security systems are relatively new and have a lot of electronic data that don't just affect white-collar cases, they affect blue-collar or so-called blue-collar cases as well. Traffic cameras, license plate readers. There are license plate readers all up and down Interstate 85 on the way up here. And throughout the city of Washington, there was I actually had some friends who were murdered and it turned into a podcast, and the trial took place recently. And there was a lot of license plate reader evidence in that case. Gunshot detection devices. In DC, when gunshots go off today, there are sound sensors throughout the city that triangulate where it comes from. Creates a lot of electronic data that's got to be dealt with in every case. Internet search history. This is actually from that same murder case from the website for the podcast, but those are actually phones, pictures of phones that were stolen that the government actually got from a subpoena to Facebook, is how they got this evidence that they used against the defendant. Internet cell history. This is internet search history. These are search results that the defendant in that particular case used, and he very helpfully for the government, after he committed the murders, searched out things like 10 hideout cities for fugitives, 5 countries with no U.S. extradition treaty, and how to remove iCloud from iPhone 6. So he actually had somewhat of at least enough sophistication to know that there might be trouble lurking up there in the cloud with respect to electronic evidence. Fitness trackers. A couple of years ago, I taught a weekend course at Vanderbilt on how to defend a criminal case, and the last exercise is, as a class, we came up with a checklist of things we would do if we were defending a case. And all the students, the federal judge who I was teaching the class with, and I did not come up with this, but they all said, well, you got to check all the data on your fitness trackers and your fitness apps on your phones, chock full of useful information. Location data on phones. I checked if you go to settings, then to privacy, then to location services, then to system services, then to significant locations. On my phone right now, you can find I've been to 32 cities in the past 2 years, and you can see the Wi-Fi spots that I connected with when I went there. Alexa it boggles the mind the amount of things that we may be able to find out from Alexa. And I guess I'd just say, before we dig into this a little bit more, I was on an ABA task force on criminal discovery standards that met 4 times a year, usually in a windowless conference room on a beautiful weekend day, with prosecutors, defense lawyers, judges, and academics debating what the ABA standard should be for criminal discovery. And one of the things on the agenda at the beginning was electronic discovery, and none of us, we were all of a certain age, none of us wanted to deal with it, and especially the state court prosecutors did not want to deal with it. They said, we're going to continue to do our cases with a small pile of paper. And the truth is, that's just not the reality because of all these devices we've just seen. And every case has electronic discovery, and we've got to deal with it. And by the end, we had at least somewhat of a consensus about how we ought to do it. So what I want to do is sort of walk through a typical case from investigation through trial, and talk about the electronic discovery issues that come up, what the theoretical issues are for us as people in the criminal justice system, and what the practical issues are. And I want to start by talking about a grand jury subpoena that many of our clients get. And we'll talk about search and seizure of data in a minute, but let's start with a grand jury subpoena. And Ann, I'd like to start with you. As a prosecutor, what sort of factors does the prosecutor consider when she thinks about whether she's going to issue a subpoena or have a search done?
Well, I'm sure everybody's had a lot of experience or some experience with both, but of course a grand jury subpoena is issued during the investigative stage. The prosecutor may not know very much at all about what she's looking for. There just has to be a possibility or potential for a federal crime to be underway or have been committed. And so that gives a much broader swath of possibility at a very early stage for a federal prosecutor. The grand jury subpoena can go to witnesses, it can go to subjects, it can go to targets, so you can really subpoena any number of people or places. So in a white collar case, at an early investigative stage and all the way up to indictment, it's a great tool. You can be stealth while you're doing the prosecution. So if those are things that are important, and they are in, I would say, most white collar cases, that's clearly the way to go. You can be gathering information literally for years without detection. Obviously, a search warrant is going overt, and so and you also have to have judicial blessing of your search warrant. So you have to have probable cause that a crime's being committed, and the place to be searched is going to have evidence of that crime. So it's a completely sort of different for a white collar case. You're going overt. You think that information may be destroyed, and you've got to go in big.
So Meredith, would you rather, if you've got a client you're representing, would you rather receive a grand jury subpoena or have a search and seizure executed, or as my clients like to call it, a raid.
Yeah. So I don't think any of your clients who call it a raid would like a raid, right?
Yeah.
I don't think they would prefer that particular action being taken first. I think most clients, if not all, would prefer to have the feeling of control of responding to a subpoena, being able to collect the documents that they believe are responsive, sort of know what is going out, know what's in there, know what problems there are, maybe get ahead of them before producing. Whereas a raid, it is disruptive to your business. It's worrisome, it's troublesome, it can be in the papers, and you have no control at that point. It's a sort of a triage effort at best on the day of. So I think my clients would like me to answer that the subpoena response would be better.
And Simon, as an aggressive defense lawyer, would you rather receive a grand jury subpoena or have your client raided?
I want the raid. Setting aside all things that's bad for the client and it interrupts the business, I think a raid results in a process that the government can generally only screw up, and it usually comes in the form of taint teams, okay? And those of you who have been on the government side know that being on a taint team is not what you would call glamorous duty, right? It's just reviewing documents and is there any inkling of privilege? And what's worse about it is you get no credit when you do it right, but you're blown up in a big way if you do it wrong. And so for me, from a purely legal standpoint, I think a raid is an opportunity for mischief. It opens up a different front in the war that is not on the substance, but rather on the process. And I prefer the raid.
Let me throw one other thing in there on the raid side, from my perspective on both sides, and that is that when there is a search warrant rather than a subpoena, it really puts the burden on the government. You're going to go in, you're going to take all the computers, and the government has to be the one to sort through that, rather than us doing it and then handing it over with a nice index and a guide to the evidence against our clients. And I'll tell you, the government is not. They're not good at it. I mean, it takes a long time. It's a blunt instrument. They don't have the resources. So, I mean, depending on the situation, it may not be the worst thing in the world.
And it is a big difference, I think, between having an individual client and having a corporate client, because I think a raid can literally shut down a business for a corporate client, right? When all of the computers disappear and your employees are sitting around looking like, great, what do we do now? It's a problem. As far as an individual, it's less of a problem. Although what's interesting is all of those devices that Rob showed earlier, those will be seized. I mean, I've had clients who have lost their heart rate monitors, their alarm clocks, because you can plug in your phone into your alarm clock, which means there is a possibility for data storage. Anything that could conceivably use for data storage can and will be seized by the FBI during that process, and it's a pain. But the thing is, and I don't want to focus this on the defense side, the reality is it's a pain for both sides, like Ann was saying. It's not just that the defendant loses, or the potential defendant loses all of these things. The government's got to figure out how to look at all of these things before they can return them.
And let me jump on the raid bandwagon then, since my colleagues have turned on me. I think, when I was thinking about this, it might also, and this ties into what we're going to talk about later, it might be less expensive for a client in the long run. And sort of ripping off the Band-Aid in a way that a painful, long, drawn-out subpoena response process is exhausting, time-consuming for a business, all those sorts of things. So there might be, an upside in that way as well.
So last year, Mark Ray was on a similar panel from his former FBI cyber guy who was at Nardello, who says, not only the raid they don't even have to come to your place to do a raid a lot of times. They can extract a lot of the data from the cloud, or they can do it remotely. And let me, I often hear about something called a clean team. Can you define what a taint team is, a clean team? And then the follow-up question is, are either of those assignments plum assignments that assistant U.S. attorneys are eager to have?
Yeah, no. So as Simon was saying, the taint team is, the suckers who get no role in the case because they have to look for privilege, and if they've been exposed, obviously they cannot breach that wall. Of course, the clean team is on the other side of that wall, and so that's actually the better assignment.
Okay, so let's talk about what happens when you get a subpoena. And I want to put up some language from a recent subpoena that some generic attachment that was on a recent subpoena that Simon and I got. And I want to read some of the first lines here. It says, documents image are to be produced, and then it says all documents or files are to be scanned, i.e. paper documents, or printed out to CCITT Group 4 300 DPI resolution single page TIFF images. Each container file, such as an email, PST, or NSF, or file container such as a zip file or RAR file shall be extracted. Each container item is to be considered a separate document. The parent-child relationship between the container and container item is to be maintained. You're younger than I am, did they teach you that in law school? And what the hell does that mean?
No, although I do know people who are now teaching a discovery for associates class at Georgetown, a seminar like this, but I think that is the exception, not the rule. Look, I can tell you what most of this means. I mean, a TIFF image is very simple. It's just a picture of the page as opposed to the actual document. A parent-child relationship is a fancy way of saying make sure the email attachment stays with the email. So this is a lot of complicated language to just talks about the form of the production. The problem with this form is not necessarily here, the form. The problem is that the department itself doesn't follow this all of the times. It's honored in the breach as much as it is. I felt bad yesterday because Meredith said that she thought she was the only one who actually complied with these DOJ procedures. I thought I was the only one. There's at least two of us. The problem is that when the department doesn't apply this uniformly, and then your client gets indicted and they produce discovery to you, they are producing a mishmash of discovery in various formats that are not consistent, which makes setting up a review process very difficult. So I actually am sympathetic to this gobbledygook language. I think they're on the right track here. I think the problem is that most people ignore it, and no one at the DOJ really seems to care unless they do. And it's the lack of uniformity, to me, is a bigger problem than any type of specification. Because I find when you actually call them about these specifications, you're going to get one of two issues. One, they're not going to have any idea what you're talking about, and like, but your name's on the subpoena. Oh yeah, I don't know that. I don't know the technical stuff. Or two, they're actually going to have a very reasonable, principled discussion with you about what they really care about and what form they're looking at.
And it's also.
Go ahead. No, Meredith, go ahead.
It seems like it's also one of those things that you get very little credit for complying with, or no credit. But then if you don't, and you do run into an AUSA who, fancies themselves an e-discovery expert, or finds this to be an important part of a production, then that's where you can get crossways very early on. So it's expensive, it's time consuming, and something we spend a lot of time on, but it only really can backfire. It doesn't get you any favors by doing it right.
So I liken these attachments sort of to civil discovery requests in a big law firm. As time goes on, every associate or lawyer looks at them, adds some new ornaments on the tree, and sort of makes it better. And pretty soon people are just or corporate documents for that matter, and people are just sort of mindlessly using them over and over again. And that's this particular attachment's been used at Maine Justice since 2015. Here's another one. This is B, native electronic files are to be produced. And it says native electronic files are to be produced in addition to the TIFF images, except for structured data, i.e. MSXL, MSAccess, .exe files. Does that make any sense to anybody on the panel? Is this a good idea or a bad idea?
I'm one of those ex-DOJ people who never read that stuff or understood it. So, So I mean, I have absolutely no idea what any of that means, and even now.
So
it's
Simon and
wrong.
Meredith probably knows what it means.
It's actually back. It's 180 degrees from what you would really want in a competent document production. I never produce natives until they ask, and then I produce the natives, because if you go to court over natives, you're going to lose every time.
For those of us from many generations, what's a native?
A native is kind of the actual, say it's the Word document itself, as opposed to just the image of the Word document. And the native gives you additional information that you might not have in the image of the document, for example, a track changes history or other things. What's laughable about this is To me, the most important document type that you want in native format is Excel spreadsheets. And it's the one thing, it's actually carved out from their native production requirements. So whoever actually drafted this language doesn't understand in any way, shape, or form how modern discovery works. I mean, I have literally had requests from other side that says, I don't want any natives except Excel spreadsheets. So this is 180 degrees wrong in my view.
Okay, let's go to the next instruction. It says a single document level Unicode text file is to be produced for each record. And if we go on further down to the fourth line, it says for files where the text of the document is not electronically extractable, this file should be imaged, then processed using optical character recognition. What does that mean? Meredith?
Yeah, I'm happy to translate that for you, Rob.
Yeah.
It means a PDF.
I actually think I might know, but I'm just checking.
It means a PDF document where you can extract the text. You OCR it, which means you can sort of pick out the words in it and use it in a searchable format. The problem with that is, even with the best intentions, we are all in cases, I imagine, where handwritten notes are, critically important. And if OCR is not done at all or OCR is not done well, those are virtually unsearchable, and you can have reams, books and books and years of calendars and handwritten notes that you can do nothing with but read them page by page.
So the government wants things in OCR, optical character recognition, so they can perform searches on them, right?
Right.
Is it reasonable for us as defense lawyers to expect the same when they produce things to us? And one of the questions I'm sure we're going to get, and hopefully we'll preempt and talk about, is what do we do when we don't have the resources to deal with all these documents? Well, one of the things you do is you run searches. But can you run searches on can you run searches that are real effective if the documents have not been OCR'd?
No.
Well, let me give you one. So before I came here, in the last couple of weeks, I spoke to one of our chief judges and our chief judge in the Western District, and a magistrate judge, who the chief judge pointed me to and said, I don't know anything about e-discovery. Talk to the magistrate judge. So that was an interesting point, number one. The chief judge doesn't know anything about e-discovery. I talked to the magistrate judge, who says, I don't really know much about it, but let me tell you about this motion that was just filed by a solo practitioner in the Western District who was doing just what Rob said, which was asking the court to require the government to give him documents in a manner that were useful to him, or that he could search, that he could organize, or to have the government organize them, because the discovery was of such volume and complexity in different formats. And in his motion, he said, undecipherable, unreadable, and basically just wanted to throw all that at the magistrate judge and say, make them be better, make them make this more fair. And the magistrate judge was, I think, enlightened, having never had a defense attorney ask for this, but denied, because there's no mechanism in the rule to require the government to do that. So, and then, at least in this case, the government didn't do it voluntarily. So it's a tough place to be.
Here's the next instruction that was attached to this subpoena we got. Says a concordance compatible file is to be produced. Each file produced will have a corresponding record row in the data file, and then there's what are called field names, and there are those, and there are eventually 42 of them that they expect. Anybody on the panel, what is concordance?
Concordance is the government's document, or at least it was when I was there. It's the government's version of their document organization system.
It was the cutting edge review database 15 or 20
Therefore, it's the government's.
years ago. I think it's maybe longer. I know there are people in the crowd who can correct me on the timing, but
And is there a database that's considered more state of the art now, or at least state of the art is not the right word, but more widely used?
Really interesting with that.
Yeah, relativity, right?
Yeah.
And Simon or Meredith, do you produce, if you have your documents, and if you want to try.
I'll just shut up.
If you have your documents in a Concordance database, are you going to produce them to the United States government in a Concordance database as they have as the court has instructed you to do under the subpoena that is being issued under the court's name?
I mean, we don't produce out of, a concordance database, but we can produce in that format such that the government can easily ingest it. The reverse is not necessarily true.
Right.
Yeah, I don't. I'm not saying that I ignore these, but I do produce all of what I would call the standard information, and that is the to, from, dates, custodians, basically any of the normal, typical metadata that you would expect and that you would expect to get in a civil case. I mean, what's ironic about this is if you didn't provide some of the stuff in a civil case, at least a civil case that's, say, worth 8 figures, you'd get sanctioned by the same magistrate judge for not producing discovery in a usable format, the same magistrate judge who won't rule in a criminal case that similar discovery needs to be produced in a usable format. So this is not...
Slowly, what is metadata?
Metadata is kind of the information behind the face of the document that provides additional information. So it might tell you, for example, who drafted the document, when was the last time they accessed it, whether there was track changes or edits that are somehow stored in the document, the file path for the document, where it was on a server or computer. And then in an email, the metadata is pretty simple. It's the to, from, BCC, CC, subject matter, date. And the date can be really important on the metadata because litigators, we like things in chron order, right? We like to recreate life as it happened at the time. And without the metadata as simple as sort date, your life is much, much more difficult.
Simon, did we have any issues with e-discovery in the Stevens case? And can you tell us how those were addressed?
Yeah, I mean, this is a good example. One of the productions from the government was an 80,000-page PDF that was locked from a security standpoint so that it could not be OCR'd or any other analysis done to it. And there were no page breaks. So you didn't know when one document started and the next began, which was particularly difficult because there were spreadsheets in there. And if you print spreadsheets to PDF and then you put them back to back, you have no idea what you're looking at. And I went to Judge Sullivan, who was generally sympathetic and is a reasonable, fair judge. And I said, Your Honor, this is outrageous. We have an 80,000-page PDF that's locked and can't be OCR'd. And he looked at me and said, that sounds good. So you have what you need, Mr. Latcovich. No, not at all. I mean, I was like, no, I'm sorry. Maybe you don't understand. This is really bad. And I think that the key for us in this room, and I think as Ann talks about judges who these issues just haven't been brought to them, I think you have to bring these, we need to start bringing these issues to the judges early in a way they can understand. And to Judge Sullivan's credit, when I said, well, how do I explain this, Your Honor? It's the equivalent of, call it 20 or 30 banker's boxes of documents in which every single paper clip or staple is removed. And the judge says, well, why in the world would you do that? That would be outrageous. You can't do that. I'm like, yes, here we go. And so his response, of course, was, why don't you two go to the jury room? You know, you two sides go to the jury room and talk this out, which led nowhere. So I do think it's an issue that, like Rob said, I actually think it is the biggest problem in criminal defense in the next 5 to 10 years. And I think not criminal defense, criminal prosecutions, I think the government is going to have the same issue. They're going to be overburdened with data and not know what to do with it. And I think it's actually the only way we can avert some of this is to present these issues early and often to the courts. So both for educational reasons and to get guidance about how to do this.
I hesitate to use this example because a lawyer who was on the case is in the room, but, and you can correct me if I'm wrong, Aaron, but we had a case where same thing, and it's not that judges are not intelligent. I think they understand that a terabyte or multiple terabytes of data is a significant amount of data, or they understand maybe that an 80,000-page document is not helpful. But an illustrative example of what that means, like what Simon said, which is it is a lot of boxes with no staples. We had a discovery motion where we said these files that are being referenced are buried in 13 subfolders in the middle of a giant folder, an electronic folder, that when you print out, it takes 84 pages just to show you the depth and the length of the folder. How could we ever possibly find this? Nothing is named. It's all in just sequential numerical order. There's no way to get there and to understand what we're looking for. And the government is saying, here it is, of course, why couldn't you find this? And so using illustrative examples to sort of help educate the court might be a way to help get there in some of these log jams.
Mm-hmm. Hey, Simon, who was Magistrate Judge Faggiola?
Judge Fasciola was a magistrate judge in DC who took it upon himself to get very, very smart on electronic discovery. And you will see that some of the leading cases in electronic discovery were written by him. Unfortunately, he's since retired, and there is no heir apparent. I mean, there's a very good judge in the District of Maryland who tends to write a lot of these opinions, but and you know, people know there were in the SDNY there were certain opinions that came out about electronic discovery, but there is not anyone of the Judge Fasciola mold that I'm aware of today that's really pushing these issues and pushing awareness on these issues, and I think in part because the failed amendments to Rule 16 can be read as a caution to judges of, hey, stay out of this, right? The rules, we tried to amend the rules, it failed, so don't play. I actually think the failed amendments, they failed in part for a different reason. That is, we don't want to bind judges' hands. We want to give them free rein to do the right thing and come to fair outcomes. But I don't think there's judges who are comfortable enough with their knowledge on the stuff to do that yet. It's not that they don't want to do the right thing. And part of it, by the way, it's not that the DOJ doesn't want to do the right thing. I just don't think people know how to get there yet. Mm-hmm. I think we're all in the same, we can be in the same boat on some of this.
Mm-hmm.
So I've got a slide up there that says virus protection, encryption, and security for delivery of production data. And it reads, production data shall be free of computer viruses. And then down below it says, media shall be encrypted using BitLocker, McAfee, or an alternative encryption solution that does not require installation of software to the workstation. What does that mean, and do you comply with that, Meredith or Simon?
The second part certainly means like virus software.
Yeah.
Okay, fine. The second part is basically password protect your productions. If you're going to give something to the government, you should wrap whatever it is in. If it's in a hard drive, it's in a folder, wrap that in a password and give it to the government via separate correspondence. Certainly in the healthcare world, for HIPAA reasons, you're going to want to do that. We do it for all of our productions now just as a client protection measure. It's also very amusing. It can get fun at points. I had an insider trading case, I guess it was a year and a half ago, in which I produced documents to the government, and 7 months later, and they were demanding now, you've got to produce, I got the subpoena just before Thanksgiving as it happens, and you better get us these documents before Christmas. So I got them the documents in the first week in February. And by the time it was all said and done, in September, they wrote me and said, hey, did you ever send us the password for that disk that you gave us? Which, so passwords, they do work. And sometimes they provide additional insight. But I think that's really what that means, as opposed to, BitBlocker or whatever else.
And I think there was someone here, I think it was last year, that admitted that they always change one digit in the password. Not for every production, but every now and then, to see which of the productions are being loaded and actually reviewed by the government. And if they don't come back and say that password doesn't work, then maybe they haven't loaded that set of documents up yet.
I like that.
Okay, practice tip. All right, this is the last, I think it's the last one, at least the last one I put on the slide. This says audio multimedia file specifications, and says when producing audio files created from recorded phone calls, the metadata fields below should be produced in addition to the metadata fields previously identified on the specifications document. Can you unpack that for us? Meredith or Simon?
Yeah, I mean, we've all recently been involved with cases with significant amounts of audio files, and I'm not sure that we got any metadata on ours, much less participants, call date, start time, all this. And to suggest that that is an obligation of ours to produce is a little bit one-sided.
Yeah, I mean, the last case in which I got a serious dump from the government on that, I got about 10,000 recordings, and the file names were, I believe the file names were the date and time of the recording, which was somewhat informational, and that was it. That was all the information we got. No who they are or anything else. And so this is one of those things that, you know, I laugh and it's honored in the breach. The government doesn't collect its own information, and the government can't blame that on a third party. You know, that was collected pursuant to a warrant and consensual recordings, all supervised by the FBI. So the FBI doesn't actually follow these rules when it does these types of collection. And by the way, practically, this is not easy to do. I mean, if you're doing a voice, for example, a voicemail, a company voicemail, and I call Ann and I leave her a message, and somebody pulls that file, it's a data file. You can label it as a custodian for Ann, but unlike the other metadata that you can extract from the document and dump in a file for the government, you would have to manually fill in some of this. And so it's actually it can be a cumbersome process.
Yep.
And sorry.
No, go ahead.
We also talked about the ways that our firms have managed audio files, and particularly the expense of that. I think Williams & Connolly has experimented some, and we have with transcription services or sort of automated transcriptions that'll create searchable files. Those are difficult at best, particularly when you have strong regional accents, I understand.
Arkansas and voice recognition does not mix, I've learned. I love the accent, but.
And that's if you can afford it. We had a case with multiple defendants with pretty good resources, and we're not able to afford that. And so we put a team of staff attorneys. Williams & Connolly has put teams of summers on them that put on headphones and, you know, start typing and identify calls that may be problematic or noteworthy, and then more work is done on those. But it's an art, not a science, to get to these and to figure out the most cost-effective way to get through tremendous amounts of audio recording.
So I'm a little ahead of where we're going to be, but let's do this now. Lightning round: more recordings, audio recordings, or less audio recordings in cases now than when you started?
More.
Yeah, I'd say more.
And is there a good technological solution for dealing with this? For example, one might think that you could take all these recordings and feed them to a computer, and out would pop beautiful transcripts that you could then do word searches for. How well has that worked for those of you who have tried it?
I think that it's different than the olden days where you literally did have to sit and do it by hand. So you can get a starter kit basically by using the transcription software, but it still requires someone to go back and correct. So I mean, so that's the cost and time issue that I think we can't get around.
And to go back to your point, Simon, that the government, when they issue this subpoena, puts all these burdens on us as recipients, that they want us to do this and that, and you do some of it, some of it you don't. It's certainly subject to negotiation. But would that job be easier if the government produced those audio recordings to us in the form that they've asked us to produce them to the government?
Absolutely. I mean, just imagine that if you've got a cooperating witness and you're able to quickly pull out all of the calls or recordings between two witnesses, right? If you're just able to sort by who's on the call, that's a massive advantage as opposed to when we had to brute force review 10,000 calls. And by the way, we learned during that brute force review that 4 of them were calls in which we believe the witness was soliciting underage women while he was cooperating with the FBI, and this was being recorded. Of course, none of that is identified in any way, shape, or form because there's no people, and we had to find the 4 recordings out of 10,000 that showed that, and that just goes to show the difficulty of kind of needle in the haystack here. I do think the technology will get better. I mean, for those of you who have Alexa in your home, like me, who can't convince my children to get rid of it, despite my concerns about it, or Siri or whatever, we are seeing the voice recognition improving, but it is, the problem is the level of accuracy that we need is not quite there yet, as I'm sure many of you have learned anytime you try to ask Siri for something that's more complicated than what's the weather, so.
Okay, let's get out of the details and go now to a higher level of the subpoena. And let's say your client just got this subpoena. What are the first steps you're going to do when they get this broad subpoena in terms of sort of preserving the status quo. And Simon, I'm going to ask you this because our hero and mentor, Brendan Sullivan, always says, appoint a custodian. And he always gets a little confused when we tell him there are two meanings to custodian when it comes to responding to a subpoena these days. Can you unpack that a little bit?
Yeah, I mean, the first thing I say is don't destroy anything. Please preserve everything. If you have any auto-delete, turn it off. I mean, to me, that is the only mandatory initial step. I think everybody in the room knows that. You know, you're proceeding at your own peril. If you don't do that, and by the way, you need to document it. And I know lawyers sometimes think they need to document it for their own self. I think you need to document it for your client's sake. I think you need to, because you need to be able to prove later that your client, in fact, got that preserved documents. And the best way to show that is to show that they were instructed to do so. Custodian, it is, I personally, when I started, I felt like you had a corporate client, you had to have a document custodian. Find somebody, usually somebody who knew nothing about the case, so that if they got a grand jury subpoena or something, all they could talk about was the document collection process, and you'd put them in charge of that production. That's, you know, different from who are the custodians or the people whose documents we want to collect. I've found that recently, and maybe it's because of kind of the expanded meet and confer process, document custodians don't matter as much at companies. I don't see in my practice the government reaching out and saying, I want to talk to the document custodian. Because what they do is they reach out to me and say, tell me what your client did to collect and produce documents. I'm now expected to know that and be conversant in that in a way that 10 years ago it was like, oh, well, I'll get the document custodian. So I think it's important probably for process reasons, but I think practically the document custodian has been replaced by us.
I agree with that.
So almost 30 years ago when I started, I was taught, whatever you do, don't make decisions about responsiveness, appoint a custodian, give them a set of instructions that you can defend, and then let them make all the decisions. Mm-hmm. And those expectations, I think, are completely reversed now. I think we as lawyers, absolutely in civil cases, I think the rules are required, but I think in criminal cases as well, we have to be involved as well. Meredith, what role do vendors play in this process?
That can vary depending on what you want them to do and the capabilities of your client, but they can be and often do become an important part of the team.
What does it mean to process data? Is that a necessary step?
It is a necessary step in order to...
For those of us who are older, explain what it means to process data and whether who needs to be involved to do that?
Well, so the vendor can help do that. So take the example of a global investigation or something. If you select a vendor that can have consistency across multiple jurisdictions, across multiple continents, they then become a part of the team, answer the questions that the government has about the collection process, and really become embedded in those early decisions and discovery, sort of setting the path for your discovery for the case. They can also collect the data in a way that maintains all the things that we've been talking about this morning, in a way that is forensic, and so that you can spit back out all the things that are being requested here. So if the client collects it, or the client says, well, I'll go to the different computers and copy everything, you often lose that. And so using a vendor who has control, who has the capabilities, and who has the technology to collect it in a forensic manner maintains the things that the government is expecting when you output it later in a production.
Is another way of saying that the vendor can help you create an audit trail to defend the integrity of your production? Yeah,
and that's a way for you to focus more on the facts and the case and let them worry about, or sort of entrust them with what their expertise is, which is creating that audit trail and making sure that things are done right from a technological standpoint. You can't be completely hands-off, but they can be the experts.
On that note, this is going to sound odd coming from me, given my background in Williams and Connolly, and I may be shunned by some of my partners after saying this, but I actually think the most important thing you can do in the subpoena compliance and in the criminal case is full transparency to the government. And I think you just have to tell them, here's who I'm searching, here's how I'm doing it, and here's when you can expect documents. Yeah. And you put that in writing. I put that in letters, and I document it, and I just let it go, because that way you've protected your client, right? Everything has been run by the government. The other thing is, half the time the government doesn't pay close attention to those things as they probably should, because they're running multiple investigations. This may be early in the phase. And 6 months or a year later, they may realize that the process that you set forth didn't get something that they wanted, and they frankly might be too embarrassed to come back and ask because they signed off on this process a year ago and it's in writing. And so to me, it is the one, Katie bar the door once your client gets indicted, but if you're talking about the document production process, I think the only way to protect your client and the best way to frankly be tactical about it is strange enough to be fully transparent about what you've done.
I'm surprised to hear you say it. Unsurprisingly, that would be my tactic. Given my background, we do very detailed transmittal letters to the government.
Yep.
This is what we did. This is how we did it. Even to say, we're not sure that we got it all. We reserve the right to come back. Just so that we are attempting, and it's not as easy as you might think it is. I also think the government thinks that companies can push a button and get things. We need 6 years of employee data, and you can just push the employee data button, and that's never true. So I think part of that is to also, help them understand you have asked for something, and this is the process by which we are attempting to comply, and it's hard.
So you've got your beautifully processed data that Meredith has described that you can forensically justify. What do you do next then to sort of narrow down this massive, if you want to narrow it down, which let's assume you do, this massive amount of data? How are you going to winnow it down to something that's more manageable?
Well, I think one of the things Ann mentioned is the scope of the time period that the government is looking at is often imprecise. So a first point of negotiation is usually, what time period are we going to start with, and can we narrow it down from the 10 or 15 years of data that you've requested in the subpoena? So that's a really good start. And then, Simon said yesterday he negotiates everything. I think a next point of negotiation is talking about having a really robust discussion about search terms and how you're going to apply those to narrow a universe, to narrow a huge amount of data into a universe that is manageable. I told the story last night when we were preparing that we were negotiating with a really young AUSA who'd come from a big law firm and trying to negotiate search terms, and he told us he was quite sure that his big international law firm never applied search terms before they reviewed data. And we told him we found that very difficult to believe, and that when the documents popped up at his computer as a young associate at this big international law firm, we were certain that the partners above him had negotiated search terms. So there can even be what seems to us as a very standard, preliminary, sort of customary step. You can face challenges even doing something like that it just sort of starts things off on an interesting foot. But if you're Simon, everything is negotiable. And I think certainly search terms and the scope, the time scope is a good place to start.
Do you tell the government what search terms you're using? And if so, when?
I do. The when is actually an interesting question, because I will sometimes, depending on how cooperative I'm being, I will give them the search terms before I run them to see whether they have any comments on them, and that is the safest way of doing it. Sometimes, though, if I'm in a more, shall we say, adversarial role, I will give them the search terms as part of the product, like, here is the production, and like Ann said, I will have a detailed description of exactly what we did. Here are the custodians that we searched, here are the terms that we used, here is the date range we applied. Thank you, have a nice day. I do believe everything is negotiable, and I think it's even more negotiable today, because I think there's a lot of young AUSAs today who spent more time doing civil work at their law firms. And it's one of the reasons why they wanted to leave. They wanted to go try and do criminal cases, and they want to be an AUSA, all of which I think is commendable. But I think what you're seeing is the import of civil discovery requests into grand jury subpoenas. And I think that they're just uberly broad. I also think if you're a young AUSA, it's easier to ask for the sun and the moon and the stars and then have me come back and say, that's nice, tell me what constellation you're really looking for here, and I'll give it to you. But if you want the sun and the moon and the stars, I never go to court over grand jury subpoenas unless it's privileged, but I'll go to court over this one. I mean, I had one that said, I want every calendar entry for your client for the last 5 years. Every single client, or every single calendar entry. I thought that was absurd. That might work in a civil case. This person had spent 5 years in the SEC before they had come to main justice in the fraud unit. So I do believe everything is negotiable. And I think when you tell them, Rob, really turns on, I don't want to say whether you're pulling a fast one or not, but just how cooperative you are being. Or want to be perceived as being. The reality is you're complying with the subpoena. Sometimes it's actually a perception issue.
And another reality is that many times the grand jury subpoena has been written by the agent, who is way more conversant into what they want for their investigation, and the AUSA, especially early on, is the conduit. So when you're doing that negotiation, you really should think about having the agent present. To be able to guide the AUSA, frankly, in what they're looking for. And I don't always do the search term negotiation. And I think there are some AUSAs who are reluctant to do that because they own the outcome. And some AUSAs will say, I'm not going to tell you how to do it. I'm telling you, what I want. So I don't care whether they do or they don't.
So we've talked about processing the data, narrowing it down with search terms. Is there a role for human beings after you've applied your search terms, and what is that role?
I mean, there's no way. I look at it differently in terms of subpoena compliance versus trial prep. So if I have discovery and I'm putting together my trial, that's obviously a human process. There's no AI that can help me identify the documents that I'm going to use for my defense. On the other hand, if I'm doing subpoena compliance and I have a comfort level with what AI can do, I think that machines can do a lot, but there has to be some component of that where you have eyes on, not maybe every document, but some system by which you are checking behind, your.
So let's take this in order, and then I'll try to move on here. In terms of just pure subpoena compliance, do you, either lightning round or just somebody speak up, have human beings go behind after the search terms and look for privileged documents? Do you use machines to at least do an initial privilege review, or do you just produce it?
I do both. I have a number of search terms. I mean, sometimes it's simple as the law firm, any lawyers involved, names, just simple searches to flag particular documents, and then I have a human lay eyes on each of those documents. Although I think in today's world, even that can be negotiated away, and especially given the prevalence of clawbacks. But my view is I still want eyeballs on each document. I'm I won't say petrified. The idea of turning over a critical privilege document to me is still scary, hard to stomach, even with clawbacks. Ann, you talked a little bit about artificial intelligence, also sometimes called predictive coding. Is there a role in subpoena compliance, do you think, now, and will there be in the future for an evolving artificial intelligence sort of review process that improves based on learning? And does anybody have any experience with AUSAs buying off on that as a way to comply with subpoenas?
Yeah, I mean, I think we're there in a lot of ways. Meredith could probably speak better to this, but we had a big case in the Western District that was a massive environmental case, and it was just simply too big for all parties on both sides to manage. And predictive coding was used. There was buy-in by the government, buy-in by the defense, and that's really how the thing went forward. So, and I think that is getting better and better. But there's absolutely, I think, especially for subpoena compliance, and if you can afford it, that's a big part. We're talking, here as if, we all represent companies and companies have unlimited money to do it. But if you're in a big document case, then it's necessary. So let's talk about the elephant in the room now. Let's talk about cost. Does the government care how much all this costs, especially if you truly are representing a third party? Yeah, I think the blunt answer is no. Because if you go back and say, do you really want this? There's almost no AUSA that's going to say, no, I don't want. If you say, do you want, the answer is yes before you've finished the question. But I do think that you can sit down, I think, as part of the negotiation process and say, it's going to take this much time and it's going to take this much money, just letting you know in case you're unsure. And I've done that with some success to say, again, I think there are times when the government thinks you just press a button and you're going to get it. So I don't think they care, because if you challenge them and say, do you really want this, their knee-jerk reaction is yes, of course I know what I'm asking for, and yes, I really want that.
Rob, we had a case that the cost of just hosting, so holding the data in our system, the case-wide data in our system, was running at around $30,000 to $40,000 a month just to hold it. And at that point, that's not sustainable. And so we had to make decisions based on search terms and time periods and custodians and various parameters of what we would continue to host, and sort of made our critical mass and what we had to offload. We just could not afford it.
Yeah.
And there's part of me always that wonders, what is in this set that we pushed to the side, that we had to push aside? And what if you start down a rabbit hole that turns out to be important, and the rabbit hole stops because the rest of that trail it's what's been offloaded? But you just have to do some practical things in a case of the volume and the size and the length that we're talking about. And those are tough decisions that you have to make as a defense attorney.
So Simon, you say you negotiate everything.
Yes.
Does your negotiating leverage change if you represent somebody that you think is a target of the investigation, as opposed to somebody who's truly a third-party witness, and of course, obviously, there are variations in between as well?
Sure. I think as an initial matter, the government's less likely to be cooperative if you're representing a target of investigation. It's been my experience. But at the same time, you do have an active production privilege that the government, you may force the lawyer to say, well, do I want to play nice in order to avoid an invocation? So I think the answer is it depends in that context. I will say on the technology side, I've never had, I don't know how many people have ever had a government lawyer ask them how much is this going to cost. I've never had that conversation, and maybe I should. I do think there are ways of technology that's decreasing the cost. We had an experience with a massive FCPA investigation where we told the government, we're going to use predictive coding, we're going to review 10% of the documents, and that's going to push automatically the documents the computer thinks are more responsive to the front of the review queue. And when we did that, we were getting much higher responsive rates in our batches, 50, 60%. And the catch is, we said when it gets down to a certain responsive rate, like 5% or 10%, we're going to stop reviewing. Because we think at that point it's diminishing returns and it costs too much. So what's the advantage to you, government? You get the more important documents sooner, because we're talking millions and millions of documents. And the reality is, I think it saved the client money, even though they had to pay for that predictive coding, because there was no attorney eyeballs on the tail end of those documents, right? And so the real negotiation there is, how big is the tail? How big, for subpoena compliance, how big is the unreviewed tail? And so I do think if you have sophisticated AUSAs, you can have these types of discussions, and they will sometimes be receptive. At some point when you're talking about 10 million documents from a multinational company, the idea of just putting an eyeball on each document, if you really want to cure that, I don't think money works. I think the way you do it is what I heard Ann say, at least I thought I heard Ann say, is, let me tell you how much time it's going to take to review this many documents. We're going to have a massive team. We'll put 25 lawyers on that. You can't ever complain about that. But if you use a typical review rate, and you have 10 million documents, which, oh, by the way, might be 50 million pages, we think we should have our production to you sometime in 2024. Thanks, we'll talk then. And I think that is, to me, that's been the best leverage that I've been able to use.
Let's shift gears here. And Simon, let's say you've asserted your Fifth Amendment privilege not to produce documents under the Act of production document privilege, and you get a call from your client who says, we're being raided. And you, of course, say, boy, it's working out just the way I hoped. And
All part of the plan.
and what are you going to tell your client? Do you have any sort of like quick reaction instructions to the client when they tell you that a search is going on at their place of business?
I do. It's be polite, be respectful, and keep your big mouth shut. It's very simple. And the next question that inevitably follows is, when are you going to be here? And the answer is, once they're gone. Okay, you have to, because I think having a defense attorney on the scene gives the government a out if something goes wrong. They said, well, Simon was there, he saw what was going on, he never raised any of these issues with us. And so to me, and clients have trouble understanding this until you have to explain, I think, it is to their long-term tactical advantage that they are there, but not your attorneys. And that's hard because there is nothing more intrusive than the blue windbreakers coming in and rooting through every drawer, everything you have in your life. They want their safety blanket, they want their lawyer, and I think you have to be firm that your presence there is not helpful.
Meredith, let's say your client says, okay, I don't know, would your practice be not to show up as well?
You know, that's interesting that Simon says that. It depends. We have some clients that want to have a list of contacts for each of their facilities, who they can call and who can get there within an hour. And so I think, you know, there's a differing perspectives on whether that's...
So let's say your client's 200 miles away from the closest Alston and Byrd office.
Right.
And you don't have local counsel on the ground wherever they are, and they say, I'd like to take out my cell phone and record the agents and what they're doing. What would be your reaction to that? Good idea, bad idea?
I think the agents would not appreciate that.
I think they're going to seize the phone. Thank you, we
right.
were looking for that. Yeah.
I thought you were going to go a different way with the phone question. But
So the next question then, then the next question is, the one that I may have telegraphed to you better than the one I just asked, is what if they say, here's the warrant, it calls for your phone, and by the way, I want to know your 6-digit password. What do you tell them then?
So I think we all came down on the same way last night, which is no passwords. We would not be willing. We would plant the flag there and say no passwords. The question of company phones is a tricky one. And it might turn on the bring your own device policy. It might turn on a number of things. But the first and most important thing is something you already pointed out, which is whether the warrant covers it. And so that's a preliminary question. And then sort of take steps from there. But we all agreed last night that we would not give passwords over.
And just litigate that. I mean, I don't think you have to be, mean about it or, obstructionist about it. Say, here's the phone, but, we're not going to give the password, and we can talk about that later.
So, okay, fair enough.
I mean, by the way, it is tricky with bring your own device, because if it's a corporate device, look, the corporations don't have a Fifth Amendment right to privilege.
Right.
But if it's my own phone, I do have a Fifth Amendment right. And if you're a company counsel, you don't want to be put in a situation where you're deemed to be an arm of the investigation by forcing clients to put in passwords on their own personal devices, right? It can get, actually, if you're a government lawyer, it can get very messy very quickly.
Yes.
So I think litigate it, and it's the only safe way.
I agree. And I'm one of the people who still carries around 2 phones from my old government days, and I still do it just because I'm paranoid.
So two final questions on this. Let's say your client calls and says, there is privileged data on this server. Should I tell the government that there's privileged data on this server?
My answer is yes, but I would be general about it. There are, you are seizing electronic devices that contain communications with my counsel. I just want you to be on notice of that. And then I think the counsel has to then follow up almost immediately after the search with a letter to that point. But I don't have a problem with that being the only thing you say. And when they ask which devices or et cetera, I would demur.
I think that's the way to do it. I mean, you're just planting a flag, but I don't think it's going to have any real impact in the moment with what the
That's
government
right.
does.
They still have to. I think they still have to seize it, right? They have
Yeah.
a warrant for it, and they're going to take it.
So Simon, in just a few sentences and we'll move on, you're the most aggressive proponent for the thesis that a raid is a good thing. What can we expect in the days, weeks, months, and years ahead? Just sort of give us a laundry list of issues you might be litigating after a raid.
Look, I think privilege is the easiest one. The scope of the warrant, I think, is one that is not, it has not quite been litigated to the full extent yet, but as we do more and more with electronic devices, as they collect more information about where we are at every minute of the day, who we meet, et cetera, it really feels like we're getting into this idea of general warrants, that are prohibited. This idea that the government can learn everything about you as opposed to a specific target information. And so I think one of the next issues is going to be in seizures. Does the government still get to get everything, or do they actually have to target better within devices? To me, that's going to be the big issue. But I actually think there's going to be less seizures going forward because everybody's putting their stuff in the cloud, and it's so much easier for the government to drop a warrant or even an administrative request on Google, Apple, et cetera, to get 95% of the same information without you knowing and without going through a warrant process or a raid process.
Bruce, you got a question?
Yeah.
Yeah, with respect to the raid, I've always wondered, one of the things that the agency want to do with the raid is to sequester all the employees and tell them they can't leave the property and start interviewing them outside the presence of any counsel. And I wonder how comfortable you feel telling your client over the telephone when you get that call and say there's 50 agents here conducting a raid, say communicate to the employees that they're not under arrest, the plant's closed for the day and they're free to go home.
Ann, you want to take that one?
Yeah, I think that's a must, Bruce, because I do think that is a tactic that's time-honored tradition and is still being used. In a case that I've been working on, that's exactly what the FBI did. They went to the company, they had a swarm, it was a search warrant, and they sequestered everyone off, and folks were interviewed. And for hours, 4 hours, 5-hour interviews. So without a doubt, the FBI does it because it works. And I don't think that it is and I also know this, that if you say to the FBI agent, I'm not going to speak to you today, we'll talk to my lawyer, they're fine with that. They know that, and it's not going to create any kind of ill will. So it's really just a tactic that they try because it works.
And the only really effective antidote to that I've heard, and I wouldn't recommend suggesting it to the client, is to pull the fire alarm.
So I got one point I want to make out of deference to Mitch Mitchelson, who raises this every year with me. He says, you got to start talking about the duty of the government to preserve data and putting them on notice. And so I actually did some research. I had some more slides on this, but I'm going to summarize this point quickly. And that is, if I have a client who, I've never done this, but if I had a client who I was confident was going to be indicted, and I thought there were government agencies with electronic data out there that ought to be preserved, I would write them a letter and say that it has to be, tell them they have to preserve it, and I would explain to them why I think the information is exculpatory. And Larry Youngblood is the reason why. He was the defendant in a case called Arizona versus Youngblood in the 80s or 90s, I believe it was. And he claimed, he was charged with sexual abuse. He claimed that the government let the biological samples degrade to the point where they weren't subject to serology testing. And he made his case that if you'd only preserve the data, not let it degrade, or preserve the samples, it would have exonerated me. He went all the way up to the United States Supreme Court, and the United States Supreme Court said, no claim, because you can't prove it was exculpatory, and there's no bad faith on the part of the government, and they weren't really, there was no bad faith on the part of the government. Lo and behold, when DNA testing comes along, it proves that he was innocent, and proved another person did it. And his case basically stands for the proposition that the government has to know it was exculpatory and has to act in bad faith, or you don't get any remedy for spoliating evidence. So my thesis would be that if you had you have to think about whether you want to show lack of confidence in your case by sending a notice to the government to preserve these sorts of things if you rather act as though you can't believe that they would ever indict. But if you did, I think Larry Youngblood's the reason you need to put him on notice. And we'll call that the Youngblood-Michelson corollary. So
Who does that? Anybody done that?
nobody,
I've
none of
never
us
done
have
it.
ever.
Yeah, we've
but,
never done it. It's curious.
so anyway, so let's talk about what happens post-indictment now. So Meredith, back to the very beginning. Now you've got your, this brave new rule is in place that you have to have a meet and confer. What sorts of things are you going to talk about at your meet and confer with the government about electronic data?
I mean, I think, something that I foreshadowed at the beginning is this rule doesn't talk at all about, well, it doesn't give any details. And so talking about the types of data that may be in play, the volume of that data, what it looks like, how quickly it can be exchanged, and also sort of the timeline for this rollout and the expectations on both sides as to when these things can be reasonably accomplished in light of learning the volume and the nature and things like that. I think those are obvious points, but without a clear, there's some guidance in local district courts and local, different judges that might have checklists and guidance that you can refer to, but it's really a choose your own adventure the way the rule is written right now.
So I'm putting up my one little thumb drive can hold 75 million pages worth of documents slide. Let's talk practically. How do you deal with that? Anne, you've represented alleged billionaires with seemingly unlimited resources, but this is daunting for anybody.
Yep.
Can all of you sort of walk us through various strategies you employed to take the millions of pages and winnow it down to something that you can use to actually defend your client and think about it from a number of different budget and resource perspectives?
My strategy is to only have billionaire clients. Makes it much easier. But short of that, I still think that if you're now, if we're at the post-indictment stage and you've got speedy trial issues, this is where I think getting the bench up to speed on what you're facing is important. Especially what we'll do, and this isn't really dealing with the data as much as it's dealing with the court. But if we're making a motion to continue, which we have to do, my alleged billionaire may want to go to trial immediately. I want a trial now, I want my trial in 30 days. But you can't, because the government is not only giving you millions of pages of documents, but they're trickling it out. And I think you probably have all experienced here's some, 2 months later, here's 1 million more pages, 2 months later, there's another 1 million pages. And that has the effect of requiring you to kick the can down the road. So in motions to continue, I like to let the court know specifically what is happening, so that they're sensitized to what's going on. But we've talked about in terms of dealing with massive terabyte level information, and you simply have to use resources. You've got to figure out, if you don't have a billionaire client, how to use machines to help do what humans can't do. And whether that's going to the court, if you're in a joint defense group, that's helpful, but cost sharing and just kind of muscling through.
Yeah, talk about joint defense groups a little bit and what role several lawyers working together can play in terms of dealing with the data, and what you have to worry about in case things go turn sideways with your co-defendants.
And I'll just talk from the boomer level, so it won't be highly technical, but and wrong probably. But the idea on a joint defense document review is that you can have a central database that everyone has access to, password protected. So everyone, what we've done is do a joint first level review. So we get a review protocol that all defense counsel can agree upon. Do sort of a broad-based, bucketing of documents. Then on the second level review, have a cloud-based way to look at the documents that you are looking at simultaneously with your co-defendants. So you can share the cost of that sort of time-consuming initial review, and then partition it off to do your client-specific second-level review, sharing what you decide to share, just like you would in any joint defense agreement, either everything, something, or nothing. And that can be a time and cost saving.
Simon, have you had any especially good or bad experiences with working with joint defendants in a review environment?
Yes, I mean, I've had good experiences, and it's just similar to what Ann described. And you basically have coding that the entire joint defense group can see, and then you have your own walled off coding so that you can generate work product in the database that won't be shared with anyone. And I think that's an important way of doing it. At the same time, you know, the SDNY 2 weeks ago sent me a request saying, we'd like to talk to you about a list of documents. All of them had been produced by the company, except one of them had an internal Bates number that was produced, that was given to someone in the joint defense group as part of a joint defense agreement, and clearly somehow that document got flipped to the SDNY. So still sorting through that drama. So I do think there are dangers in providing access to that much information, particularly if you represent a company and it's an employee who you're giving access to a much wider swath of information than they might otherwise see, right? If they have access to more than just their documents thereon, I think it can be dangerous because you're educating a potential future cooperator. Mm-hmm. Of course, it's not really conducive to a joint defense group to call your joint defense members future potential cooperators. So it's a fine line you've got to walk there.
And Rob, I think another challenge that can come up is if the counsel representing members of a joint defense group have different capabilities. So for example, if there's a solo or a small firm, medium-sized firm, you know, we have the benefit of a lot of resources at a large firm. And so when there is disparity among sort of different capabilities among the joint defense counsel, that can create challenges and tensions among the lawyers as to sort of the burden sharing of the review and the work and the searches and things like that as well, which can create further challenges.
Can we go back? I want to dovetail on something Ann said about what to do when you get this data dump. To me, the most important thing you can do is get a hold of what you have early and go to the court and ask for the information that the subpoena, grand jury subpoenas require. Ask for the date the document was generated, the custodian of the document.
Takes us back to the very beginning, what we talked about.
To the very beginning, because if you can put documents in chronological order and you can text sort them, you can triage a large amount of documents much easier than you can absent that data. And so to me, the first level response is you've got to get in front of a judge and explain that the government has dumped a large amount of data without the typical information that itself requests from parties when these documents are produced. I've had dreams at the very beginning of a production saying, very beginning of investigation saying, dear government, please make sure that when you collect documents in this case, you comply with all of your electronic discovery standards so that if this case ever proceeds, we will have a functional, useful database that wouldn't get you sanctioned in the civil world. I've never had the guts to send that because it does seem a little bit defensive to be talking about what your post-indictment discovery database is going to look like at the beginning of an investigation. So I still haven't.
So the three of you all work at large law firms, and I actually invited a couple of federal defenders here, and they were too busy doing their day jobs to come join us. But imagine yourself in a case with a federal defender and 5 court-appointed lawyers, all with 1 or 2 or 3 people in their office. And you're told by the government that there are 1 million pages of discovery. What advice, if you were brought in to give some pro bono advice to that joint defense group or to that group of defense lawyers, what would you tell them?
For me, this is when I would go to the court to say it's a due process violation potentially. I mean, you really have to go in there and say fundamental fairness requires the court to step in because we are in an impossible situation. Funding has to be made available, maybe through the Federal Defender's Office, to empower these lawyers to be able to defend their clients. It really, to me, I think we should start thinking about it, e-discovery in due process terms.
Yeah, Brian.
And on that point, where you have terabytes of information, Rule 16 talks about items that are material to the preparation of defense, and items that the government intends to use in its case in chief at trial. And I think asking a judge, to your point, to have an affirmative obligation on the government to identify those things well in advance of trial can be helpful and save a lot of time.
Yeah, I mean, the Brady, it's sort of, we talked about this a little bit at the beginning, since Brady has a materiality requirement, it's sort of a love-hate thing that we as defense attorneys have with that, because we've complained rightfully about the government making the decision about what's material to our defense, and we don't like that. So we've argued that's wrong, you should give us everything. So now we get everything, and we're saying, hey, that's wrong, you've given us too much, and now we're swimming in this ocean that we can't deal with.
But I have noticed that judges seem to be more favorable towards imposing an affirmative obligation on the government to
Totally.
identify trial exhibits well in advance.
Yes. So if you're in that posture, yes, you can do a scheduling order, and I think part of that is getting ahead of, this is how we want to be efficient, court, because courts love efficiency, and so get in front of the judge and say, let's do the scheduling order, and it's going to include these things this far out, and this is why this is going to be efficient.
And we really poo-pooed the changes to Rule 16, but there is, the new Rule 16.1 says, go to the court, request court action, utilize us. Now what that looks like, I don't think we really know, but it seems like an invitation to, again, chart your own path and ask the court to get involved early to help with that.
So in your materials is the relatively new federal bench book on e-discovery in criminal cases. And if most of the judges I know say I didn't take a pay cut to become a judge, so I had to deal with e-discovery. But I think they have to. And it's I think it's a very useful document to cite. Also, the joint protocol that was met up called JETWAG, there's a guy named Sean Broderick who's with the Nationwide Federal Defender System, whose primary job is to try to make e-discovery accessible to people who don't have the resources that large firms have. And I think he could at least be sympathetic. And my view is that we have a responsibility as a profession, and I think the ABA could play a role in this to try to figure out how we're going to manage this, how we're going to standardize things, how we're going to make it so that it doesn't feel so unjust. So any questions? Yeah.
I had a question about Rule 6 of the e-discovery rate. So the Don Blankenship case, the guy from Massey Cole,
Yep.
now the court is recommending
The magistrate, I haven't read the opinion, but yeah.
recommended that
Yeah.
the conviction be overturned because of Brady violation. In the pre-trial, the defense filed a motion that there were 4 million pages of discovery and said, court, order the government to, if they are aware of Brady, specifically to identify it. And the court said, the court finds that the United States should specifically designate any known Brady material as such and disclose the same to the defense counsel. In other words, without more, the United States does not comply with the requirement of Brady by merely including all known Brady material within the 4 million pages of discovery. I've had a little bit of experience with the case that the pre-trial was about 4 years ago, but I'm interested in the panel and whether you pushed that and had any ability or success in getting the government to comply with that so you can find that Brady needle within the discovery data.
Yes, I've pushed it. I have not been as successful as they were, or I mean, maybe they were and they weren't. I mean, depending how it came out. But it's and usually the response I get from AUSAs, which is not, I mean, I'll admit it in this room, but don't quote me on it, it's not completely unfair, is, well, we don't know what your theory of the defense is, so we don't know what's actually Brady. And my response to that is, fine, give me what you know. I understand that caveat. There has to be things in there where you look at it and you go, that's not ideal. Fine, tell me what that is. But I do think that is, these are the kinds of, I don't want to call them shortcuts, but efficiency savers that I think people need to push for in that case. But I personally have not been very successful. I've been more successful at times in doing what Brian is doing and saying, okay, you've got 10,000 recordings, government, so many months in advance of trial, you have to identify at least the potential universe of recordings that you're going to use. We're not going to hold you to it, but limit that world. I've had more luck there than I have with identifying specific information.
I think that's because that's judicial efficiency, and that's just always a nice trigger for the judge. But I haven't done what you've suggested, but it sounds like another one that we should all be doing because it's the core of Brady, and it's a fundamental fairness issue, and I think that you can sort of get judges to think about that, even if they find no, like in the Magistrate Judge case that I talked about earlier, where the judge denied the defense counsel's motion, but at the same time it caused him pause, and maybe the next time he's going to be more sensitive to it.
I had one more question.
Not so much a question as just a statement going back to talking about working with lawyers in smaller firms or CJA. So when you don't have $1 billion
Yeah.
independent, because I am from a small firm, I do CJA work, the courts will give us money to host the data and also money to pay for, in big enough cases, a lawyer whose sole job is to manage the discovery for you. And so that's been a great resource.
That's fantastic.
Somebody on your defense team who's saying, help me find these documents, show me how to use the database.
Oh, that's great.
Wrap up real quickly. Predictions, any big ideas, predictions? Meredith?
Well, Simon has the biggest, so maybe we should let
Okay,
him
Simon.
start.
I don't know if it's a prediction, it's a crazy idea. I think there needs to be a third-party entity that manages discovery in criminal cases. And it would be used by AUSAs during the collection process. These would be subject matter specialists who are not involved in the investigation, but rather they run the database, they ensure that the database is documents are in the proper format. I mean, think of them as like litigation support folks, for those of you who have big firms. I think it does a few things. It takes the burden away from AUSAs. They're not managing the technical aspects of discovery. Post-indictment, you'd be able to provide immediate access to the defense of all of the documents in the database. You wouldn't get the work product of the government, but you would get the documents themselves. And I think you could segregate, just like you do in joint defense groups. The defense wouldn't see the government coding, and the government wouldn't see our coding. And I think there is, like I said, there's some precedent. Ann was talking about this in joint defense groups in the DOJ. Any of you guys who have litigated classified information have probably dealt with the litigation security group, which holds all the classified discovery and acts as if a neutral. And in my experience, they've been pretty good at acting as a neutral. I respect them. I think it has some advantages. I think it takes the burden off AUSAs of having to manage the technical side. Some of them can't do that, and none of them want to do that. I think it unifies the form of production and gets rid of a lot of the disputes that we've had today. And I think it's a cost minimization thing. I think instead of having, if you're a solo lawyer, you don't have to pay for hosting or go to the court and get money for hosting. It's already hosted by this third party. Now, I don't know whether this third party is part of DOJ, whether it's a separate entity, whether it's a vendor who's providing these services pursuant to government contract. But I think at some point, the deluge of data it's not just going to harm the ability to defend a case, it is going to really affect the government's ability to investigate a case, because you're going to have FBI agents and AUSAs who've got to collect information from the 4,000 devices. What is my refrigerator going to tell them in 5 years? I don't know. It won't be good, I don't think. And so I think at some point we need to radically think about what the discovery process looks like in this country and propose amendments that would, crazily enough, I think be more efficient and provide better access for both sides. I don't think this is about giving an advantage to one side or the other. I will probably be thrown out of Williams and Connolly for proposing some sort of joint collaboration like that. So I've enjoyed my last day as a partner at Williams and Connolly.
This will be the Chateau secret. Any reactions?
I think my reaction is I'm with Simon on this, and I'm sorry for the association. But
You're not helping me.
I know. No. But no, I think that's how we have to go. There has to be, the data is only going to get bigger and bigger, and so we all have to figure out how to be efficient about it.
I'll close by saying I think it's a crisis, and it's going to become worse. And the ABA and the prosecutors and the defense and the bench. And what you said about the good reception you're getting from judges is one of the best things I've heard. So, but we're all going to have a role to play in it.
Yeah,
Thanks.
Yep.